Good afternoon. Welcome to the law. This is your legal rights and health law. This afternoon, we are taking our time to unpack, break down, and bring to your understanding what it takes to remove a justice of the Superior Court from office for misbehavior or conduct that the Constitution frowns on. How to remove commissioners of SHRAJ, NCCE, and the EC. The Constitution provides a path that when they have acted in a way known as stated misbehavior or incompetence, or for some ill health, they may be removed from office. What is the process as laid down in Article 146? The Chief Justice has been petitioned to be removed. That petition has been thrown out as being incompetent to be able to remove the Chief Justice. EC boss Charlotte Osei was removed through a similar process. SHRAJ boss Loretta Lamptey was removed through a similar process. An NCC Deputy Commissioner was also removed through a similar process previously. How is this done? You want to know? So, if you have to take some steps, you will know exactly what to do. We are very fortunate to have two lawyers who have had the opportunity of being involved or actually doing this process called the Article 146 process. So help me welcome Ni Papo Samuel Addo. He's head of firm at Addo Legal Attorneys. And also Julius Opokwe-J, who is head of firm at Opokwe-J and Company. Gentlemen, thank you so very much for making the time to be here with us.
Extremely grateful.
Thank you, Santa.
Grateful to your audience as well.
Right. I know that they have had to make a lot of sacrifices to be here, and especially Ni Papo Samuel Addo. Thank you so very much. So, let's begin. People have heard in recent times Article 146, Article 146, Article 146, and they are hearing commissioners of institutions are being removed through it. And they've heard one that has just come and has been thrown out against the Chief Justice. Ni, what exactly is it?
Article 146, and good afternoon to your viewers as well, and listeners and those who are watching us online. Article 146 is part of our constitutional structure and architecture, and it is basically meant to deal with the removal of justices of the Superior Courts. And when we say justice of the Superior Courts, we are talking about justices of the High Court, Court of Appeal, or Supreme Court. And also is also meant to deal with persons who hold positions that have conditions of service and qualifications equivalent to justices of the Superior Court. So, i.e., the heads of our independent constitutional bodies like SHRAJ, like NCCE, like I believe the National Media Commission, if I'm not mistaken. It's not, yes, you need, you could check right on that. But I know that the independent constitutional bodies whose commissioners and whose offices, like SHRAJ and others, whose office conditions, including the qualifications and the removal, are tailored, or the language is tailored as to that you must qualify to, for you to qualify to hold the position, you need to be of this standing as Justice of the Superior Courts. And then your conditions of service are also tied to that. Then the removal is also then means that your terms and conditions of service will include those or equivalent to that of a justice of the High Court. So when you are going to be removed, then the same procedure must be adopted for you. Okay. So that is basically the architecture that we have developed as a constitutional provision to take care of the removal of our Superior Court judges.
All right.
So
let's hear what Pukweje will have to add to that.
Okay.
And I'm just reminding myself that we have just added one more officer who is subject to this process, the OSP. Yes, the special prosecutor and the deputy are also subject to the same thing.
Yes.
All right.
I wouldn't add much except to say that maybe to determine who is affected by Article 146, we look at the provision which sets up that office. And they usually will tell you how a person is appointed and how that person can be removed other than through retirement. So if the law says that you are to be removed subject to 146, then you are one of those whose removal must follow that process.
Okay. Why do you think this particular provision is supposed to be there when we know that any other office holders are subject to the normal processes of being taken to court, being investigated, and all of those things? Why such a special, sort of treatment for these classes of office holders?
It is because that class of office holders have to be protected. Now, we don't want a situation where the executive, which is usually the appointing authority, can decide that I no longer want this person as the commissioner for so and so, or office for so and so. So get out of office and just write a dismissal letter and let you go. So the Constitution has stated grounds, specific grounds, on which they can be removed from office, and a specific procedure. So in some, it is to protect the office holder from the appointing authority deciding that I no longer want you in office, so you must go.
So are you saying that by the architecture of our Constitution, the president appoints these people, even though, like judges, they would have come through the Judicial Council, who would have nominated them and given them to the president for appointment, and some of them are subject to parliamentary approval. The president who appoints doesn't have the power to deal with them like he will deal with ministers. Just get up one day and write a resignation and say resign, or get up one day and say you have been dismissed.
That is exactly what the position is. That the president who appoints them, or the body which appoints them, cannot remove them except through this procedure. It is to protect them, especially where we want them to be independent of the executive. If you can be kicked out of office by the executive at their whim, then you are not protected, you are not independent. You are looking at the hammer over your head being wielded by the executive which appointed you. That is what the Constitution seeks to remove, so that the Chief Justice, Justices of the Superior Court, the Electoral Commissioner, or the Commissioners, the Shraj, all those institutions, the heads, can work independently of the executive.
Why should the president have the power to appoint you and not have the power to disappoint you? In the Constitution itself, it says the power to appoint. Inherent in it is the power to remove. Well, so why is it that for judges in the High Court, Court of Appeal, Supreme Court, including the Chief Justice, Commissioners of Shraj, NCCE, EC, and now Special Prosecutor, the president appoints them, but he can't remove them? Okay,
so even with the appointment, I always say that people should qualify it. It's a nomination.
Okay.
Nomination subject to other procedures, because he does it in consultation with the Council of State in respect of, by every respect of the Superior Court judges. For Supreme Court, it's with the approval of Parliament.
Right.
And then he will then swear you in. So it is not as if he has, it's just an unfettered process. And we do that to protect the institutions. Remember that the judiciary is an independent arm of government, and it is supposed to be the bastion of our liberties. If we allow, and it's supposed to be the arbiter that determines the constitutionality of actions of the executive and the legislature. and then settle disputes between us, even ordinary citizens. If you don't protect that institution, there's always an overbearing executive. Sometimes it may not even be the intention of the executive to want to be overbearing, but the powers that we have vested in the executive, because it executes, it has the coercive powers of state. There's always the danger that its actions will conflict with the rights of an individual, for example. And when you have a lot of power concentrated in an arm of government, if you don't have a check, you understand. What then happens is that particular arm can become extremely overbearing. And our constitutional democracy is nascent. It is now developing. And we have our own history, military governments and all. We know how our system is. Somebody makes a phone call to somebody and it can. So we've tried as much as possible to make sure that the judicial arm of government is completely, independent financially, independent by personnel, and independent administratively, so that at no point should a judge in giving a decision look over his shoulder to think whether he would be removed or he can be taken out. There must be security of tenure of office, so that when you are making, because some of the decisions that, so look at the high stakes cases that sometimes go before the court.
Right.
Even the election of our president is subject to the court process. So look at our last election, the last two election petitions, the very first one. If the decision that was close, 3-4-3 in the court, or 5-4 in the court, if for any reason it had turned the other way, we should still guarantee that Ghana would be able to move on as a country and that we will not have an upheaval. And so if you place such onerous responsibility on these persons, you need to protect them from an overbearing executive. So that is the main reason why our constitutional framers, based on our own history, we've had history where Dr. Kwame Nkrumah of blessed memory sacked judges because he was not happy with the decision. We've had Busia saying that no court. You see, so we've actually had clear examples in history where, and remember, our constitution is based on our history. Yep. So our constitutional makers decided that, look, for this our republic to be able to survive, we need an independent judiciary, which is not just independent in terms of its name, but it's independent even to the point of the ability of the president or any other arm of government to interfere with the personnel of the judiciary.
Something I would like to add that apart from, or in addition to the president, let me rephrase that, we should also look again at the way and manner the holders of independent constitutional offices are appointed. That, I believe, is the source of the problem.
Yeah.
We allow, or we've crafted our constitution such that too many independent, or practically all the offices are appointed by the president. Even though some are with the prior approval of the of Parliament or in consultation with Council of State and also, I think we should craft an independent manner for appointing these persons based on merit and competence. Then the thinking to that, because I appointed you, I should have some sort of authority over you, which Article 146 seeks to shield the appointed from, would not be so much felt. So I think we should also look at how they are appointed. We should think about it.
Right. So we hear that the president appoints in excess of about 4,000 to 6,000, people to man various entities, agencies, MMDAs, whatever you call them. However, for institutions like the judiciary, the NCCE, the EC, the SHRAJ, and now the special prosecutor, they go through a process and he eventually appoints, and yet he doesn't have the power to remove them from office. This, the lawyers have explained here, is intended to protect these office holders. How can you say, and starting with Opukweje, how can you say that this is intended to protect them, and yet it is the same provision which is used to remove them from office? It was used to remove Loretta Lamte, used to remove Charlotte Osei, and before then it was used to remove someone in the NCCE. And recently it was being sought to be used to remove the Chief Justice, and then it failed. In fact, in 2005, there was one seeking to remove the Chief Justice then, which also failed. How do you say that a provision is intended to protect these people because we need them and we don't want the executive presidency that we have, which people say is an imperial presidency, to unnecessarily interfere with them, with their politics, and yet the same provisions that you say is supposed to be a protection are the provisions that we use to remove these people from office?
Well,
explain.
These provisions, something truly, are meant to protect them. Why? Because without going through the steps set out in Article 146, you cannot remove them.
Okay.
The President, the Council of State, Parliament, nobody can remove such office holders because they don't want them there. Even if you, as a president, you know for a fact that an office holder has done wrong, you might even have caused, you have all the evidence, you still cannot remove that person unless you trigger Article 146. That is the protection. It is a stepped process. Look, first of all, there must be a petition. That's the process.
Right.
By a citizen of Ghana to the president that our office holders so and so must be removed for X, Y, Z reasons. And the reasons are stated in the article itself.
Yeah.
You cannot come and say, because I saw him eating cassava by the roadside, or he has done so and so, I want him to be removed. It is stated clearly the reasons for which they can be removed. So that is some sort of a protection. I read your article, your very brilliant article on this, where you state the example that you cannot say because the chairman of so and so has chased my girlfriend or has spoken to my wife in the manner I don't like, I want him removed. Unless that behavior will fall probably under the high moral integrity, bit which
Stated misbehavior.
if it goes stated misbehavior,
Yeah,
then it can be used. So you cannot just go and say, I want such a person to be removed. There must be reason which falls in line with the constitution, and that is where the Prima facie case comes in. I mean, after the president receives the petition, he passes it.
Before we go there,
Okay.
Ni, help us. You're holding the constitution in your hand. 146.
Yeah.
Opukwaje is talking about the specific grounds by which you can invoke 146. What are they and what do they mean?
Okay.
What do they mean?
All right. So for the 146, we have stated misbehavior. We also have incompetence. This is another one, or ground of inability to perform the functions of his office arising out of infirmity of body or mind. So stated misbehavior, the case law has evolved, if you look at the Justice Derry situation. I just wanted to qualify something that my learned senior said. The referral can be made by either a citizen of Ghana or also by the Judicial Council. This is in Jabwo. There's a case, I didn't want to bore with all this, but there's a case where a justice was removed based on to a referral by the Judicial Committee. So with Article 146, you can make a direct petition to the president, or you can, if you, for example, you have a problem with, let's say, a particular judge, and you are a party to a case or whatever, because the judges are judicial officers and they are under the disciplinary control of the Judicial Council, you can actually petition the Judicial Council. If the Judicial Council finds merit in the complaint that you have sent, they actually can now make a formal report to the president, and that will be the base. So in Justice Jabwo's case, a petition was sent against him relating to his work. And
it wasn't sent to the president?
No, it wasn't sent to the president. So it was then the Judicial Council who set up a committee. The committee made some reports and then sent it to the Chief Justice. And then the Chief Justice then forwarded the reports to the president. He went to court to say that it is only through the procedure of sending a petition to the president that you can. And the court disagreed with him and said that the Judicial Council can also send a report to the president. So there are two ways of doing this. You can actually go through by a citizen directly to the president or through the Judicial Council, who can also make a report based on your...
And even before that, we also need to state that if you have an issue with a judge, you can directly send something to the judicial to the judiciary.
Yes.
Just go make the report, the complaint to the judiciary, and they will take it up and deal with it.
Yes. So,
you were dealing with stated misbehavior.
So stated misbehavior, for example, in the Justice Derry cases where there were allegations of bribery. So these formed stated misbehavior in the sense that the courts, the committee went through the citizen, Mr. Anas, through the Tiger Eye, petitioned the president directly. The president set up the committee. The committee then went through the allegations, and then they were removed for stated misbehavior. So stated misbehavior is a ground. Your own judicial incompetence can also be a ground. So that's one of the things that a lot of people don't seem to realize. That
in the US, some judge was removed for telling lies.
Correct.
On oath.
Correct.
That's perjury.
Perjury, yes.
So that's stated misbehavior.
That is stated misbehavior.
Okay.
So it should not be, or you should not think that an incompetent judge cannot be removed. It is not an immunity. If you have evidence that a judge is putting aside the law and pursuing personal vendetta, is not showing good faith to the oath of office, you have every right.
Okay.
Yes, because we can't have incompetent judges. Incompetent judges are a cancer. So if a judge knows that the law is A, this is different from a mistake. But when the principles of law are clear, and you can see that this is a judge that does not know A from B in terms of what he is doing, his application of the law.
That's incompetence.
That is incompetence. And
on that basis,
you can be removed.
But do you find that for most of the situations where these petitions are made, it is not about incompetence.
It's not about incompetence.
It's about stated misbehavior,
like bribery, like
issues of corruption,
not going to work. You know, yes, if you are a judge and maybe you are in a particular locality, you don't go to work on time. That is a ground. Because if you're supposed to sit at 9 and you've been sitting at 10 o'clock, 11 o'clock, and there's evidence, you decide that, oh, maybe on Mondays, Wednesdays, Fridays, I won't sit. I only sit on Tuesdays and Thursdays. And we think that nobody is looking at you or watching you. If there's evidence taken that you are not doing what you are supposed to do, you can be removed.
Okay.
You can go for removal. If a judge is sick, and we know that this job is a very difficult one.
So that's the third ground you are going
to. A judge can suffer from stroke, for example. We've had situations where we've seen judges who basically can't even walk and are being assisted. Obviously, how is it possible that a judge who cannot write because unfortunately you suffered a stroke and you cannot write? How do you perform your functions as a judge?
And that is the ground on inability to perform the functions of his office arising from infirmity of body or mind.
You understand? So there are situations where a judge had stroke and was still sitting to sit, basically. And we all could see that. Then what is the judge, really doing? Because judgments were not being delivered. You finish a case and for a whole year, the judgment is not coming because we all know that the judge is sick.
Right.
You go to court, the judge is dragging his feet. He can't even sit for 30 minutes. He can't concentrate. He's not lucid. I've heard where there was a judge I paid for. Clearly, you could see he was not lucid because he was not well. And because maybe the person hasn't prepared for retirement, the person is finding it difficult to resign. Where you see these things, okay, these things can be the grounds for removal because if you are reported, you will be given an opportunity to, come before a medical board.
Right. So Fukwaje, look at it this way. Would you say that the last ground, that is inability to perform the functions arising from infirmity of body or mind, is easier to prove because you may need a medical proof to do that, other than the stated misbehavior and incompetence?
Well, if you are physically unfit, what we need is a medical certificate.
Okay.
I mean, we know the functions of your job. If a doctor has certified that you cannot work, you cannot work. I sitting here, you sitting here as a non-medical person cannot make that determination.
Okay.
But once there's medical determination that you are unfit, either physically, that is in body, or mentally, in mind. It's very simple. It's very easy. But I have never come across it being used here, even in spite of what you are saying about the 146 being used to remove judges. I have never come across it. And as for what you also, the examples you gave, which is very serious. I mean, incompetence is incompetence. But probably because we are very reluctant to measure the quality of people's work in this country. We've never used competence as a basis for removal. I've never heard of it here. And I think it arises out of our reluctance to hold people to the standards that are expected of them.
Then lawyers will be more guilty here because they work in the court.
That's true.
And they will be able to know if a judge is exhibiting incompetence or not, and not their clients. So if lawyers are not invoking the incompetence part, they are to blame.
Well, invoking
or
it
that is to suggest that all the judges are being competent throughout.
No, Samson, you and I know at the bar, you hear complaints about the competence of this judge or that judge. And I'm also aware that there have been a few occasions where complaints have been made. Not petitions filed, I'm not aware of it, but complaints made. And then the only sanction I have seen is the removal or transfer of that judge from that court to another place to go and then inflict his incompetence.
Or reprimand.
Well, haven't even heard of reprimand. Maybe they've been reprimands.
We have done one in which the judge was reprimanded.
Okay, so that's fine. But what I have seen is the quiet transfer of the judge so he can go and inflict his incompetence on some other community.
Yeah, I'm saying so also because...
the appellate ones even. I sometimes you read a court of appeal judgment, which is actually calling a judgment of the lower court perverse. You know, meaning that it's the entire judgment could not be supported by anything in respect of the facts or the evidence adduced. I think that it is about time our Superior Court judges, when you have such a judgment, not because there is a misapplication of the law, but where the judgment,
where there is clear incompetence,
should refer these matters to the
how about the lawyers involved? Why don't they also take that on the basis of that make the complaint? And I was making the example that within the system, you hear lawyers whispering, this judge is getting drunk. It's coming to court late. It doesn't have even the presence of mind to do the work. And we are quiet.
Well, Samson, I'm quiet.
You were going to say something.
You are quiet. We are quiet. It is true.
Yes, you are quiet because there's a fear that you could be picked upon. You know, because obviously, if the lawyer files the petition, it is the lawyer that is going to be, you know, held, you know, to prove the allegation. But sometimes, for the larger good, you know, perhaps you would tell a senior who is, you know, we work with seniority. So the things I can do, Justice Mr. Opoku can do even, you know, because of his seniority. So you look perhaps for a senior lawyer, 30 years, 40 years, and maybe pass the information on. And they could also then take it up. But we should be bold to start weeding some of these things out of the system. It's not healthy.
Right. So what you have just been educated about here, forget about the emphasis on judges. Because the law says a justice of the superior court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. And you see throughout, it talks about a justice of the superior court. You have been educated to understand that this same provision applies to holders of the offices that are known as independent constitutional bodies. The NCC commissioners, Shroud commissioners, EC, and now we have added the special prosecutor and their deputy. And as Ni and Loyopoku Eje explained earlier, it is because these people who are not judges, the conditions for their appointment is that of this kind of condition, which is the condition for judges. So it applies to them. So if you have been seeing or you are aware of these commissioners conducting themselves in a way that falls under stated misbehavior, they are committing some crimes, they are acting incompetent, or they are ill and still don't want to resign and keeping the office, you are entitled to make a complaint. Now, how do you invoke the process? Let's start with Opoku.
Well, as we have indicated, you start with a petition.
Okay.
And Ni has reminded us that apart from a citizen petitioning, the Judicial Council can also report your conduct to the president for removal.
Okay.
But this, let's all remember that when you are going under Article 146, you are not asking for the judge to be suspended or punished in any way except to be removed from office. Yes. Especially with the judges, there are other modes of their conduct being subjected to some sort of sanction by the Judicial Council. Yes. But if you go under 146, whether it's for a judge or any judge of the Superior Court, the Chief Justice, or the commissioners we are talking about, then you want that person to be removed from office.
Right.
You prepare a petition. As a citizen, you can prepare your own petition and send it to the president. Okay. Written, when we say petition, it is in writing.
Right.
You can't go and knock on the president's door, book an appointment and say, I've come to report Commissioner so-and-so or Judge so-and-so. It should be a written petition. Okay. Sent to the president. And then when the president receives it, he will pass it on to the Chief Justice. If the removal is for anybody apart from the Chief Justice, then the president will pass it on to the Chief Justice, who will then look into it to see whether a prima facie case has been made. Now, the law doesn't say how the Chief Justice should look into it. The law doesn't state how the Chief Justice should look into it. So what I know has been done in the cases past is that the Chief Justice will contact the respondent, the person against whom the petition has been made, to also talk about it, bring his side of the story. But I am of the opinion that the Chief Justice can make that prima facie determination without contacting the respondent if the petition on the face of it has absolutely no merit. It's like when we go to court and you file your claim, your statement of claim, and then your opponent attacks it that even if everything you say there is proven, you have no case. Right. It discloses no cause of action. That's what we will say, lawyers will say. So I believe that the CJ, in such instances, without even contacting the respondent, can make the prima facie determination.
And in fact, because prima facie means what? Okay, you are going to say something.
There's a small debate there. Small debate to the extent that in the same Jabo, Justice Kwame Sojabo versus Attorney General, the process of
determining
the prima facie case. Again, if you are coming by what Lawyer Opoku said, then perfectly. It must be on the merit. So your petition will live or die based on the contents therein. No, especially if it's not with respect to the Chief Justice. Then your petition must survive or die in terms of the prima facie determination precisely on what has been given. Okay. For those of us who've had the opportunity of doing the ones against the judges, where the issue of the prima facie determination was to be done, two procedures have evolved. One is what you have said, where in the Justice Derry and the others, what the Chief Justice did, Justice Georgina Wood did, was to call the individuals. So it's either you come or your representative, the lawyer will go. Then she will play the tape. And so it's a fact-finding process. That is how. And
when you say play the tape here, they are playing the evidence.
The evidence. So in those cases, there was the audio visuals that were presented. So what she did was she invites you.
And remember what he's referring to is the ANAS
situation. So she invites you. In three of the circumstances, I represented the judges. They didn't go. So what she then did was she had a secretary, and she was there. She sits at the head table, and she asks the tape to be played. Then she asks you a series of questions because it's a fact-finding procedure. That's one of the key things that was litigated in the ANAS versus Justice Derry, Justice Derry versus ANAS case. Okay. That is a fact-finding procedure. So it necessarily involves the officer undergoing some exercise. So that was one of the reasons why the Supreme Court in that case said that the Chief Justice had acted unconstitutionally by disclosing the names of the persons that had been affected. Because our argument in court was that she had disclosed the names of Justice Derry, Addo, Logo, and some others before conducting the Prima facie funding. You know, that was a novel situation. So the Judicial Secretary issued a press release and named the judges against whom the allegations had been made. Our point at that time when we went to court was that even by naming them without conducting the Prima facie hearing, and that the Prima facie hearing involves a fact finding. You need to call the person and give the person an opportunity to respond to the allegation. And so if that process is to be done, then you must necessarily do some form of fact finding. Okay. And so the process that she adopted was that she will call you, play the audiovisuals, and ask you to answer specific questions. Is it your client or are you the one in the audiovisual? The place that the videos were taken, is it your house? She went through some, then she would now write a ruling. And so if you've had the privilege of seeing the rulings, she did the majority of the judges in the Anas case, and then Justice Sufa Akufu then took over and did the last three. You will see that each of them are rulings that they give, and they actually go through a process of telling you how they came about the Prima facie.
It's like a judgment.
It's like a judgment.
The Prima facie determination, that is written out. I mean, I have the one involving Sanapo and Charlotte Osei. It's like a judgment, like referring to authority, defining what stated misbehavior is. All that is like
just like we have seen in the Chief Justice's own.
Yes. Very good.
The 11-page that they have done.
Yes.
Very good.
When I did the Loretta Lamte one, the Chief Justice did the Prima facie determination, and it's a full decision. So you read it, and she says, we took into account the evidence. We also called Loretta Lamte to bring her side of the case, and we have looked at both, and we think that she must come and answer.
The point I was also trying to add there was that some judges have indicated in some of the cases that because of the principle of natural justice, if you make the determination without hearing from the other side, you can open yourself up for a procedure where the person is going to challenge you for not giving him or her the opportunity to respond. I'm coming. That is just something that an observation that one of the judges made in one of the decisions. So he was of opinion that it is important for at least your response. Whether it doesn't really matter whether you are.
So what I was coming into say something.
Yeah,
sorry, before
you say that, but I don't want her to forget something. When I asked the Prima facie, you said on the face. So I will need us to get our audiences to understand what we mean by Prima facie, which is the most important thing that should be done to determine whether your petition will be investigated or it will be thrown away.
Yeah,
but finish the point you want to make.
It ties in with this, that being given a hearing, natural justice, can only be complained of by the one against whom the decision has gone.
Okay.
If you don't hear me and you give a decision in my favor, what am I going to complain about?
That one is very, very true.
Yes.
That one is very true.
So where the Chief Justice, or in this case the Council of State, receives the petition, they don't talk to the respondent, and they make a determination in the respondent's favor. I don't see what complaint the respondent possibly would have.
I get you.
Yes.
But
the other, let me finish. The Prima facie, as you said, is on the face of it. So by looking at the petition that you have brought, looking at the evidence that you have provided with the petition, has a wrong been committed in terms of the grounds that Article 1461 states as the grounds for removal.
Okay.
If on the face of it, that is after looking at it, this is what I think the process is. So if on the face of it, the CJ thinks that the questions which need to be answered, then the CJ would contact the respondent. I received this petition. These are the complaints against you. What do you say to complaint one? What do you say to complaint two?
So for example, you say somebody has received a bribe.
Yes.
Like in the Chief Justice's complaint.
Yes.
If the petitioner was able to add, say a video of sort or bank statement, because there's a claim that the person or G, what's his name? Jidom, somebody has already paid.
So money is looking to pay more.
Some of the purported bribe. So if you have bank statements showing that he has received money from that person, Prima facie, they will say yes, something has happened.
Yes. So then the respondent must come and explain.
Okay.
How and why did this person pay you this money?
And the explanation will be done during the committee.
No. this even at the prima facie stage, the Chief Justice will ask you.
Okay.
That's why the Chief Justice will determine whether your explanation is good enough or it's not good enough. So it warrants further investigation for us to see whether we should set up a committee now to look into your matter.
Okay.
One small thing I wanted to add was that if it's the Judicial Council, in the Jabbo case, they set up a committee. So they filed the complaint went to the Judicial Council. They then set up a subcommittee to investigate the matter. Then they took the report. So the 2 reports were then forwarded to the Chief Justice for the making of the prima facie determination. So if you go through the route of the Judicial Council, there's a likelihood that they will prepare a report, an investigative report.
All right, we don't have much time, and we need to bring in our audiences with their questions to ask. But now, quickly tell us, what's the process? After prima facie, if it is positive, what happens?
The committee is then set up in the case of a judge or anybody apart from the Chief Justice. The Chief Justice will then set up the committee to look into the matter. And it is not exactly like a court process, because this is an investigation, an inquiry. So even though you, the petitioner, will be required to produce your evidence and your witnesses, and then the respondent will also do so. The judges, the committee has a right to ask you questions. It is almost like an inquisitorial system mixed up with the adversarial system. So you cannot then complain if the committee, for instance, subpoenas a witness who they think has information to bring, if none of the parties fail to bring that witness forward. So they go through that hearing with you, the cross-examination, you do everything, and then in our case, the EC case, we were required to file final addresses. I'm sure most of them do that. You file addresses like in other cases.
In the Lord Alamte, we file
the same thing. Then they give their decision, which the president has to.
It's bound by.
Has to implement.
Okay.
With the case of the Chief Justice's own, there was a lacuna, sort of. I think there was an unclear provision in respect of whether or not a prima facie case must be made. So in the Addo case, the Supreme Court said that no, because he's first and foremost the justice of the court, he too is entitled to be given and be made a prima facie case against. So the recommendation they made was that that decision should be made by the president in consultation with the Council of State. And it's never been played out except for this. So this is the first time that we've actually seen this being played out, where the prima facie was done by the president in this particular instance.
You will tell us about the in-camera and the consequences of not, because you have done a case on that, and the Supreme Court has ruled on that. And when they finish, what happens to the report? So we open the lines now to pick your questions, and the committees that they have been talking about, if it's about anybody other than the Chief Justice, then if a prima facie case is made, the Chief Justice working with the Judicial Council, are supposed to set up a committee of 3 justices of the Superior Court. Then these people will be appointed by the Judicial Council, and then 2 other persons who are not members of the Council of State and who are not members of Parliament, or they are not lawyers. If it's about the Chief Justice, then the appointment to be done with the President acting with the Council of State. And that one, there would be 2 justices from the Supreme Court, and then there will be 3 others who are not members of the Council of State and who are not members of Parliament or lawyers to sit and hear the matter. Samuel, you are calling from Teshi. What's your question?
Hello.
Yes, listen to me directly and don't listen through the TV.
Okay.
What's your question?
My question is, I have an issue with a lawyer who was... okay, let me put that. Okay. Hello, sir.
All right.
It's about judges.
Yes. You can call us on the side and tell us about the lawyer you have an issue with, and let's see what we can help you with. Yes. So what happens to the report and the in-camera process? Please tell us first about the in-camera process. What does it mean that the process is in-camera? What does it mean?
So it means that when when you send the petition to the president, you are not allowed from the day you send the petition to disclose anything about it until the full process is done.
You're not supposed to go to the media and say, I have filed a petition.
No, you're not supposed. Maybe the announcement of the process is not in breach. At least that one, the chief judge, but to disclose the contents or anything to do with the contents of it is clear. It's a clear no because it has serious consequences.
Okay.
You can actually be held in contempt. You can defamation.
Contempt means you could go to jail.
You could go to jail. Contempt of the Supreme Court or of the proceedings.
Okay.
And so nobody is yet been charged.
Yeah.
But it is something that is available for a party that is aggrieved by it. The other recommendations are, for example, a party who is defamed by your disclosure can sue you for defamation.
Defamation. In the Charlotte Osei case, she actually sued the lawyer who filed the petition, Maxwell Opoku-Agyeman, in defamation.
Right.
Yeah.
She actually did that.
Yeah, and we also did that
those
a couple
cases
of times.
were running side by side. While the defamation was pending in the High Court, we were before the committee to litigating.
And in your case, the court said you could also suffer what it called breach of injunction.
Injunction, yes.
Okay.
Yes.
Or you could also suffer damages for constitutional infractions.
Yeah. So there are a lot of sanctions that can. It actually can lead you to.
So
a lot
once
of
you
problems.
take it to them, you should seal your mouth.
Leave it. Because you see, the allegations that you are making have not yet been determined.
Okay. So you explain again later to us why it should be in camera and why we shouldn't tell everybody that I have taken a petition to the president to remove Osimesi for something they have done wrong. Yes, Collins, what do you have to say?
Yes,
hello, Collins, speak up.
Yes. I've just given a petition to the.
Your line is very bad, Collins.
Hello?
Yes, go ahead.
Yes. I've given a petition about the case.
Your line is bad. Your line is bad. I think your positioning is wrong. It's not at a good place. Hello, Adams, what's your question?
Hello?
Adams, what's your question?
My question, I want to find out if they send a petition to the president and the president forward it to the Council of State. Can the Council of State determine without inviting the principal witness?
Okay, so thank you, Adams. If you were listening, that has been answered already. Let's take the next person. Hello, Daniel.
Hello.
Yes,
lawyer.
Daniel, your question.
Thank you so much, lawyer, for this opportunity. Lawyer, I've been following the discussion, and in the case of the Chief Justice Kwesi Nyebuah, when the president forwarded the petition to the Council of State, he actually dismissed the petition upon the advice of the Council of State. I want lawyers to help us understand the role that the Council of State plays in the case of a petition against the Chief Justice.
Okay, thank you very much. Thank you very much. If you joined, we have explained all of this, but can you give just a bit about it?
The Supreme Court has held that when a petition is brought against the Chief Justice, there must be a prima facie determination before a committee can be set up. The prima facie determination is simply that they look at the petition and see whether there is merit in it.
Who is going to look at the petition?
Look at whether there is merit in it and so warrants further investigation. And that looking at the petition is what is referred to the Council of State to do. Yes. In the case of the Chief Justice, then there's the Council of State which must do that determination to see whether there is merit in the petition, and which is what was done. When they have made their findings, then they give it to the president for the president to announce or implement.
Right, but in the Ejechum, the president has a role together with the Council of State.
So it's supposed to be. What has not been done is we've not had legislation, for example, that details, because the Supreme Court made recommendations.
Right.
Luckily, we've had the first bite at it. If you are dissatisfied with the procedure, you have a right to go to court or appeal to your members of parliament to also make legislation to fill that particular...
So the president, together with the Council of State, will look at it and see whether it is worthy of consideration. Then they will let you know whether your case can go on or cannot go on. And the earlier question you were asking, whether they can dismiss it without first inviting witnesses. No witnesses are invited at this point. It's just the one accused and the one who is making the accusation. They are the ones. The one who is making the allegation, he has already brought his documents and he may have added some evidence. In this case, he didn't provide any evidence, as the thing has said. Is it Divine? Hello, Divine?
Yes.
Please
Hello.
go ahead.
Hello.
Divine, go ahead.
Okay. Good afternoon once again. Please, I want to know. I mean, from what you guys have said, you lawyers have said so far. Yes, from what you lawyers have said, I can see that if somebody takes a petition to the president or whichever body, the body which receives the petition can, just on the face of it, can right away dismiss if he or she thinks that there's no evidence or there's no strong evidence that has been made or there's no concrete evidence. He or she can just dismiss the petition. Then if that's the case, then I think that there's so much, that it will be so much capricious. No. In the sense that...
All right, thank you very much. If you are listening, listen to it again. Wrap it up.
Let me take a small bit. Look, if you are taking your foot forward, take your best foot forward. We don't encourage piecemeal litigation. That is one of the principles that is enshrined in our legal system. If you want to do something, take everything that you have.
So you write a petition and add your evidence.
Everything.
All the evidence you want.
You cannot do it piecemeal. You bring some today, bring some tomorrow.
Right.
At the end of the day, if the thing is not a serious, it's not meritorious, it's not meritorious.
I was asking what happens to the final report if the committee finishes work. The committee of 2 justices, 3 justices, and other people, when they finish and they give the report, who do they give the report to and what happens?
The report goes to the Chief Justice, who will then forward it to the President, for the President to implement the recommendations in the report, which is either the accusations have been made out so the person should be removed, or the accusations are failed so the person remains in office. Okay. And after that, there's one thing which we raised, which we didn't tie here. Now, the proceedings are in camera, which means they are secret, but they terminate, the secrecy ends at one or the other place. If the prima facie determination is made and it says that it is unmeritorious, secrecy ends. You can now go and look at the petition and broadcast. But if it carries on to and the committee is set up and then findings are made, when the president announces his decision, then the secrecy also ends at that point. So it's now in the open.
Okay. Okay. There's been the argument about the president suspending the person after the petition has been made. Yes. What does the law say about that?
The constitution is very clear that where that's under Article 146(9). 146(10). Yeah. It talks about where a petition has been referred to the president. In the case of the Chief Justice, acting in accordance with the advice of the Council of State by warrant signed by him, suspend the Chief Justice. So the president, when the petition is made, if the Council of State advises that there's some merit in it, he can suspend the Chief Justice.
It's discretionary.
It's discretionary. It's made. Okay. And then when in the case of any other justice of the Superior Courts or a chairman of the tribunal acting in accordance with the advice of the Judicial Council, suspend that justice of the chairman. So in the case of Justice Derry and the rest, they were suspended pending the determination by the committee. Okay. Immediately the prima facie was normally they will wait for the prima facie to be done. Once the prima facie is done, it means you have something to answer. Okay. So then the suspension.
What do you guys think is lacking in this whole process that needs further tightening or something? You spoke about some rules.
Legislation. I will recommend highly that Article 146 is legislated in terms of the procedure. The procedure must be clear. The sanctions for disclosure must also be done and be clear, so that there's no room for, and the form of the petition. If you look at the Addo case, even the form of the petition itself is something that there must be a standard. It cannot be that you write on a piece of paper anything and then it is some of the judges in that case wanted to even deal with what the form of the petition should be like. So we need legislation on this.
What do you say?
I tend to agree with him. It must be expanded, and it's talking about the procedure. For instance, some of the Chief Justices in arriving at the prima facie determination did not even give the petition to the petition to the respondent, but picked out what they think the respondent must respond to. In the Charlotte case, for instance, it was the committee which gave copies of the petition to the respondent and to the petitioners as well. But prior to that, she had complained several times that
All right.
she hasn't seen.
It should have come from the CJ.
Exactly.
All right. Thank you so very much. And how time flies when it's interesting. We have been discussing Unpacking Article 146, the processes and implications. And I have just loved it. Nikpapo Samoa Addo is head of firm at Addo Legal Attorneys, and Julius Opoku Ejay, head of Opoku Ejay and Company. I can't thank you enough, gentlemen. Thank you so much. This has been The Law. It's your legal light and your health law. Join us again next week, God willing, for another interesting edition. I'm Samson Ladia Yanini. Have a good afternoon.
Hi, this is Lexus Bill, host of Drive Time on Joy 99.7 FM. Listen, you don't have to worry if you miss Drive Time or Personality Profile. It's going to be live on our podcast page. Just log on to www.myjoyonline.com/podcast. You can listen to Drive Time, Personality Profile, and any other of your favorite shows on Joy FM on that page. You don't have to miss a show at all. Joy 99.7 FM, radio for discerning listeners.